Doug, we've got a whole array here of products. Let's talk for a couple of minutes about intellectual property as it pertains to drones, and for that matter, intellectual property in general. This will be kind of a good lab exercise in looking at how all the four basic forms of intellectual property, copyrights, patents, trademarks, and trade secrets, could all come together to help one product boost itself in the marketplace.
Yeah.
Maybe we'll start with, let's start with, since we've got two parrots here.
Okay.
The parrot name as a name or a brand for a line of drones. What do you think? Good or bad? Strong or weak?
I think it's pretty good. I think it kind of goes towards the stronger part of the spectrum. It's not. This is not obviously not a picture of a parrot. It does fly though, so it does suggest parrot. So I'd probably put it in the.
I like suggestive.
Yeah. In that whole scheme from going from generic, just calling something a drone, to descriptive, to suggestive, to being completely arbitrary. I think I would call that suggestive.
Right, as opposed to if they called it super drone.
Right.
That would be that would be pretty weak because that's pretty close to generic.
Exactly.
But they brand it as parrot, and then these particular models, they gave a really cute name to Bebop.
Yeah.
The Bebop drone and the Bebop drone 2. What does Bebop have to do with drones? Nothing.
Nothing. I think it's perfect, yeah.
And parrot it evokes flight. Imagine if they had called it the hippo, right? Hippo might not be that great a name for a drone.
Yeah, they should save that one, I think, for their submersible.
Yeah, exactly.
Yeah,
that would be a great name for a submersible. All right. Trademarks or brand names? What else can trademarks be?
Well, we have some trademarks over here that maybe warrant some discussion.
Sure.
This is a Low Pro. Low Pro does camera bags, and this one is specifically for drones. And interestingly enough, they've used one. They've called it with the TM indicator, Drone Guard.
Drone Guard.
Yeah. So
where do we put that on the spectrum of weak to strong? Trademarks.
That's definitely going down on the protectability scale. I think it's kind of fits maybe more in the descriptive, bordering on generic. What do you think?
I think so too. I mean, basically, you want to get as close to a 10 on a scale of 0 to 10, I think, as you possibly can. So, like for example, Apple is a terrific trademark for computers and small electronic devices, because Apples have nothing to do with computers and small electronic devices in the real world. But Apple would be a terrible trademark for a company that was selling applesauce or apple juice.
Exactly.
Because in that context, it would be generic. So the same word can either be a winner or a loser,
right,
depending on how it's used. Now, why? I'm curious about Low Pro. They had a previous business, or I'm sure they still do, in camera bags, and now they've morphed over into drone equipment bags. Is that because they want to carry the goodwill forward from one product line to another product line?
I think it was just important for Low Pro here to be able to tell people with the name of this particular bag what it is, because people are not going to know. They're going to just assume that it's for some sort of camera equipment, and so they probably figured we have our house name, we have our brand name on here. We can get by with a more or a less protectable name. If someone out there is using Drone Guard for something else, we can take a look at it and try to decide whether to pursue them. But I think the main mark here is the Low Pro, and this is I bet someone over there is thinking, okay, we know that's sort of descriptive, but we'll just go with it, because I think we need to tell people that that's what this bag's for.
Now, if a client comes to you and says, I'm thinking about launching this new product line. We've been Low Pro for a number of years. We're going to come out with some bags for the drone industry, and we're thinking about calling it Drone Guard. After you go through the discussion with them about strong versus weak, what makes a good trademark, a really good trademark versus a weak trademark, if they go forward and say, you know what, let's go for it, would you then do a clearance search first, or would you then just try to apply and register the trademark and throw caution to the wind and see what happens?
Typically, if someone has not used a mark yet, I always recommend that they do a clearance search. Because, if you're going to dump a bunch of money into advertising and products, it's just so much smarter to pick the right name from the get-go, for which you can get a domain name, you can get protected and not have to worry about trying to enforce. I mean, that's the thing that I see so much too, is not only just trying to get a mark registered that is not very protectable, but then it's trying to enforce it because it's all over the place.
Right.
And then you're constantly on the defensive in each one of those cases, trying to establish the strength or the validity of your own mark.
A lot of times what I end up having to tell clients is, look, I'll try to register this trademark for you, and maybe we'll get it registered, but the money you're going to spend in the next 10 or 20 years paying me to try to enforce this trademark, I'm going to build a new swimming pool at my house, and I'll invite you over every summer for a barbecue.
I mean, the client really has to have like a good, they should have spreadsheets showing that they're going to make so much more money by using this name to make it worth it, because having to police that much in the marketplace, it makes it difficult.
Another great reason I have found, I'm sure you have too, to do the clearance search ahead of time is when you file that U.S. trademark application with the Patent and Trademark Office in Washington, D.C., if they reject the trademark application because the trademark is either too weak, too generic, or there's a conflict, they don't give you the filing fee back.
Yeah, that's right.
Right? So you lose that filing fee right away, and you could have avoided that and saved that expense by doing a clearance search ahead of time.
And the searches are they're relatively inexpensive
compared to the cost of launching a product. Sure.
Right. They have services that do that, and often, the way I've seen it done is you'll order a search. Even the lawyer will order the search from the commercial provider, and then do their own analysis of what the results are.
That's right.
But no lawyer's out there spending, the $10,000 in time that it would take to try to do a search. If lucky. So it's a no-brainer really for people to. They're investing not just their money, but they put so much time, and it's so much part of their own personal identification that they need to be able to move forward without having this drain or this draw on their resources.
Now, I have a practice tip for the young lawyers out there, something I learned the hard way when I was a young lawyer, which is when a client comes in and talks to me about their trademark, and if they've got a name already picked out, I will often tell them at the beginning, don't tell me what your trademark is. I don't want to know what your trademark is. Let me help you understand what the rules are for making a good trademark versus a bad trademark, strong versus weak, because when I lay out what the rules of the road are, then we can talk about what your trademark is. And if it turns out that your trademark is weak, you won't think I'm intentionally calling your baby ugly.
That's a great idea. Okay.
I like to
practice tip.
All right, find out lay out the rules of the road for what makes a good trademark versus a bad trademark early.
Yeah.
I've had clients, and when I was a young lawyer, one of the first two trademark clients I ever had got up and walked out because they thought I was making a personal judgment about the value of their trademark, when I was just trying to explain that I didn't think the trademark was going to be protectable and registerable and enforceable in the court of law, and they got up and walked out on me.
And that's what I was trying to allude to. People have invested so much personal, effort and identification into this, what they've done, because they've probably been developing it for quite some time.
Right.
So it's really a big deal.
Yeah. Let's talk, Doug, for a moment about patents. I know there are 3 different types of patents: utility patents, design patents, and plant patents. I think we can exclude plant patents from being particularly relevant to the drone world. What about utility patents and design patents?
Well, utility patents are more to protect when someone comes up with a new and novel idea that has to do with the function, the way in which something solves a problem. And design patents are focused only on the particular look of something.
The ornamentation.
Yes,
the
ornamentation. Exactly.
Look. Yeah.
We saw that with in recent news with the Apple versus Samsung.
That's right.
And the shape of the iPhone and some of its features. So But utilitarian has to do with, does it solve a new problem? That's something that people have not been able to fix on their own. The prior art doesn't seem to indicate, how to solve this problem. Someone comes up with a new invention, and I'm sure that I would bet there's some patents in here somewhere.
Well, I have a feeling that since one of the key issues in drone law, in drones, is to keep the drones up as long as possible. There's probably a lot of competition in making the new and better, lighter battery. So the lighter battery that allows you to keep your drone up for longer, that is the least expensive battery, is going to be probably the more popular battery. So I bet there's a lot of invention going on in batteries for drones.
I would think so. I'm guessing that there might be some lithium ion in here somewhere.
And some are going to be, because some are going to work better than others.
Yeah.
We were talking earlier about, for a while, until recently, getting 14 or 15 minutes off a battery was great. And then I think I heard recently that one of them, maybe it's the Bebop Drone 2, I don't work for Parrot, I don't work for Bebop, but what I've heard is that the Bebop Drone 2, I believe, has an extended life expectancy on the battery of up to 24-25 minutes, which is a pretty dramatic increase.
Yeah, that would make sense. I think when you see a company progressing from a first design to a number 2, it's going to be something, a change there that the consumers are really looking for, and I think flying time is a big one.
And then on the design patent side, we were recently talking with a friend of ours who's an inventor and a dronist, who was telling us about a new patent that is soon to be issued for a winglet with a bent-up tip at the end. That is, although it sounds like that would be functional, what he explained to us is it's not functional, it's really ornamental, and he's seeking a design patent on that.
Well, that'll be interesting, because there's certainly room for design patents in this area, and that could be one of them.
I'm reminded of the unique shape, if you will, and configuration of the DeLorean automobile.
Yes.
I don't think there's ever been another car that really looked like a DeLorean.
No.
And that might have been subject to a design patent as well.
Yeah, I'm not sure. Yeah, there's plenty of room here. It seems like for design patents, and I'm sure plenty more utility patents in the world of drones.
I imagine. Doug, how do copyrights and trade secrets fit into all of this? Let's start with copyrights. Like, I'm looking at the photos here on the box of the Parrot, the Bebop, and the Bebop 2. What else do copyrights cover?
I think an important thing to consider in terms of copyrights when you're talking about drones is a lot of people attach cameras to them, like this one here, like the Phantom. And whenever a camera is taking a picture or a video, then you're going to have a copyright arise in that footage or that photograph. And so if you're a company that's hired somebody to go take drone footage of a home because you're a realtor or something like that, then you have a real question arise. Who owns that copyright in that photo or in that footage? And I think it's important for people who are hiring drone services or for drone companies to delineate in their agreement whether who's going to own the copyright, and to have provisions in there that allocate.
So get it in writing.
Yeah.
Because we know from experience, just because A pays B some money doesn't mean that A owns it.
Right.
Right. So getting it in writing can solve a lot of these problems, making it clear who owns the video footage.
It seems like that's going to be the main copyright issue, because if you spend all this money on somebody to go out and get some great footage, and you've built all your other collateral around this sort of thing, and then you end up with a dispute or something with the person that actually owned the drone or took the photos with the drone, you just don't want to be in that situation. You want to have those rights clearly spelled out at the beginning, and it's not a hard thing to do. So,
what about going to the trouble of registering the copyright in the footage once you figure out who owns it? What about going to the trouble of registering the copyright with the U.S. Copyright Office in Washington, D.C.?
Mm-hmm.
good idea or just a waste of $55?
I guess it just depends on whether you think people are going to use it or try to use it. Certainly, the main or one of the key issues, you get better protection that way because then people presumably somewhat can find out that you have a copyright, but you have enhanced remedies. But most importantly, in order to sue somebody for copyright infringement, you have to have registered it. So if you're planning on enforcing your copyright in a particular photo or video footage or something, then you need to have it registered, and registering it early is more likely to secure you those added remedies and benefits that come with a copyright registration.
Right, so for you young lawyers out there, whenever you hear somebody say, oh, I don't need to register the copyright because I sent a copy of it to myself in the mail and I haven't opened the envelope, don't believe it, right? The law is very clear that without a copyright registration issued by the U.S. Copyright Office in Washington, D.C., you don't really have the key to the courthouse.
Right.
Copyright registration, at least a copyright application on file, is really the key to the courthouse, to being able to file that lawsuit if you need to enforce your rights. And we're going to talk about litigation and going to court later, but that getting that copyright application on file is super critical. What about using the copyright notice, the C inside of the circle, the year, the name of the owner? That's easy to do. That doesn't cost anybody anything. You can just put that on your material. So do you advise your clients to put the copyright notice on their work?
I think it's a good idea for sure. Yeah.
That puts the world on notice that you consider that to be your copyrighted work.
I think there's a lot of times where people use others' materials because they just figure, well, they were posted for everyone to see, and I didn't see any mark on it, so I just took it and used it. Now, that's not a defense, but when you do take the effort to put the copyright symbol on your work, it's much less likely that someone is going to use it without permission.
The other thing I hear, probably the number one urban legend that I've been hearing for the last 10 years is, well, I found it on the internet. That means it's available, right? I can just use it. I don't need anybody's permission because it's on the internet, and the internet's for everybody, right?
Yeah, we hear that a lot.
And I've defended quite a few cases where people mistakenly thought, well, because I found it on the internet, I could use it, and turns out that's not the case.
No. So you mentioned trade secrets.
Yeah.
That's another topic here, and it does have some relation to our discussion that we had about patents, because it has to do with if you have a process or a method or something that may not qualify for patent protection, but if it gives you a substantial advantage in your business and you've exercised reasonable efforts to keep it secret, then that can be a very powerful form of intellectual property protection itself.
Yeah, look at the Coca-Cola formula or recipe and the Colonel's 11 Secret Herbs and Spices. There's no patent on those formulas or recipes, but by being kept secret and by the two companies that own those trade secrets taking efforts to keep them secret, they have very valuable assets that are going to last a very long time.
Yeah, it's important if people are going to rely on trade secrets as a method of protecting their intellectual property, that they do have a written or at least a program for protecting those secrets.
Yeah, right.
So that when it comes down to if you're going to file litigation against somebody, or you're in litigation and you get a summary judgment motion or something like that, then you can come back with and make sure that you detail for the court all the ways in which you've gone to keep your secrets from becoming public or becoming known outside of the circle of people that need to know them, that kind of thing.
In fact, you can register a copyright with the Copyright Office. You can register a trademark with the U.S. Patent and Trademark Office. You can get a patent issued by the U.S. Patent and Trademark Office, but there's no place to register a trade secret. There's no government office for that, so you have to implement your own protection plan in order to show that you've kept that trade secret a trade secret.
Yeah, and this can include everything from from the locks that you have on, where you keep things in certain cabinets,
Right.
who has access to them, password protections, logins for people who are visiting your facilities, fencing. It's all those things that would go into making sure that your information is being kept secure. And as long as you've shown reasonable efforts at that security, and that your material hasn't been just publicly put into, out there into the world, then you have a pretty good chance of surviving that element of a trade secrets.
And I have no doubt that in the development of the drones, that the companies that are developing the technology are complementing their patents and their copyrights and their trademarks with trade secrets too. There must be some secret processes and formulas and information about how this stuff is being developed that they're going to keep under lock and key.
Absolutely, absolutely.
Doug, let's talk about litigation, aka lawsuits, for a moment. We've talked about different ways of protecting intellectual property, trademarks, copyrights, patents, trade secrets. What happens when a client comes to you and says, Doug, I think somebody's ripping me off, they're doing something they shouldn't be doing, they're using my patent, they're using my copyright, they're using my trademark, they're using my trade secret. Make the bad man go away. Where do you go from there? What's the life cycle of a lawsuit from that point forward?
Yeah, well, I think the first thing to do is to try to find out what the subject matter is, what happened. Get those underlying facts. Talk to the people at the company. Do some interviews. You have to make sure that you have some good evidence if you're gonna draft a complaint and file it in federal court or state court against somebody. So you're gonna want to make sure you do a good investigation of the facts, and that will tell you: are we dealing with a patent? Are we dealing with a copyright? Are we dealing with trade secrets or trademarks? Interestingly, you can only sue to enforce a patent in federal court.
Right.
You don't see state courts adjudicating patents unless it just has to do with license rights or something like that. And copyrights as well. If you're going to sue to enforce a copyright, it has to be in federal court. But trademarks are protectable under the Federal Lanham Act, but they're also protectable under common law and statutes in the states, and so you can sue either in state court or federal court. They have concurrent jurisdiction over the Lanham Act.
Right.
So it really depends on whether or not you have, what kind of registrations you might have, what sort of trade secrets would be another state issue.
Right.
Although maybe for just a limited period of time, because there is a federal trade secret statute which has made its way pretty far, and I believe it's been passed by maybe the Senate, and it's gone to the House.
It could come online this year.
Yes, and it seems in an unusual year, it seems like that particular issue has not or has survived, partisan scrutiny. So that should be interesting. That's definitely one to keep an eye out for. And if people want to, maybe a tip for the young practitioners, there is no federal trade secret statute right now, but there very well could be soon. And who's
Maybe by the time you view this.
And who's going to be an expert in that? Well, depends on if you've read up on it or not. So it's an opportunity, I think.
So now let's say the client comes in and says, I want to sue the bad guy. You've done your fact investigation. You've prepared your complaint. You've filed it with the court. You've arranged for it to be delivered or served on the defendant. What happens next from there to closing argument and getting the jury to all stand up and applaud you and rule unanimously in your favor?
Yeah.
What happens?
Well, I think typically, once you've been able to do your factual investigation, you have to have a conversation with your client about whether or not you think the offending party would be willing to stop their activity if you just sent them a cease and desist letter, and whether or not that's worthwhile. Because litigation in a certain sense is like an extended negotiation. You're just saying, if we can't reach an agreement at the very end, then we're going to ask the decision maker, be it the judge or a jury, to make the decision for us. And so there's points all throughout a lawsuit, even after a jury verdict or a judgment, where cases can be resolved. And in fact, I think most cases do get resolved at some point. The question is, how much are you going to spend along that time frame to
Right.
get there? And so it's always worthwhile at the very beginning to try to figure out if that's something that you want to approach from the beginning. Oftentimes it is, although there may be reasons where you file suit first because you're worried about maybe being stuck in some far-flung jurisdiction, where there's issues like that, where you can sue. So those are important considerations, obviously. What your client's budget is in order to enforce the rights in a particular case is a big deal. And so that, something that's obviously going to feed into it. I mean, intellectual property cases are tremendously expensive to litigate, especially the patent cases,
Sure.
trade secrets cases. I mean, they can all involve a significant amount of discovery, not just depositions and and getting documents often in other locales. And there's a tremendous amount of research. In patent and to a certain extent trademark cases, you may be dealing with patents that are also issued in Europe or in Japan, and you may be dealing with experts or translators, or you may be looking at files or positions people have taken in other locales. And so
discovery is the whole process in between the filing of the lawsuit and actually getting it in front of a judge or a jury.
Yeah. I mean, if you're going to kind of lay things out into sort of a pattern, you'd say that, you have your initial pleadings. Someone makes their complaint, and the other side comes back and says, well, your complaint's not good enough. I'm going to file a motion to dismiss or something like that. Or I'm just going to answer, and then we're going to move on to discovering what the facts are. And then if I think at the end of that discovery period there that, we know the facts, and as we know the facts, I win, then I'm going to file a motion for summary judgment. And if that doesn't work, then we got to prepare for trial. And there may be some motion work on what the trial is going to look like, the motions in limine, talking about particular types of evidence or the order of proof, or maybe bifurcating some issues first and doing others later, and then ultimately moving on to a trial. So, and then even after the trial, you have post-trial motions. And
I remember in the old days, I used to say to a client when they'd come in and they wanted to file a lawsuit, I'd say, so are you prepared to spend as much as $25,000 to get this case filed and have us spend the next year or two getting the case ready and to try the case? And that was obviously quite a long time ago. What do you think? I mean, realistically nowadays, what should a business think they have to budget? I mean, for a case to really get it set up and go to trial. I mean,
well, I think if someone said in your example, the $25,000, I think it would be to investigate this case and get a complaint on file.
Right.
You probably have to stop right there.
Right. Not to take it all the way to the end.
Right. And there's so many variables
Sure.
that can happen. I mean, you can have cases where the other side files, it's just scorched earth and
Right.
files every single motion they possibly can. I've been involved in those.
Right.
And
As have I.
It's a tremendous experience the whole way. It's like it takes a lot of time away from your family.
Have you had any success with alternatives to courts, such as mediation and arbitration?
I think that's tremendously helpful. But it's important to get a case positioned in a place where people feel like they have enough information so that they feel like they can make an educated decision, and they're not just being, information isn't being withheld from them upon which they would really need to know in order to make an educated settlement about something. So, but we have a lot of really talented mediators that can help people come to agreements. And there's, with trademark cases in particular, it seems like there's so much opportunity for creative and interesting, resolutions
Right.
of things.
Right.
So sometimes you can get, we've had cases where the others, we just want the other side, to stop using our mark, and maybe giving some sort of incentive for them to do that. If that ends up costing so much less than the litigation, then sometimes that makes sense.
So
Obviously,
sometimes if the other side stops, your client might even be willing to throw a few bucks at them just to get them to stop.
I've seen that happen in several in many cases out there. And sometimes that makes sense. Sometimes you don't want to create a precedent of people just coming in and trying to use your marks. But when someone has maybe an established pattern, or they've started using a mark in a particular small locale and they're willing to change, but yet they've been doing it for a long time and it wasn't on purpose. No one was trying to move into your client's space or take any of their customers. Then sometimes those can be appropriate resolutions, and it can work out well that way. So.